Years ago, before gun control became a reality in Australia, you could literally purchase ammunition at Kmart. Back then, many houses, particularly in regional Australia, had an old 22 caliber rifle. In this contract case, a merchandising company, Tallerman, made a contract with Nathan's Merchandise for the supply of no less than 2 million 22 caliber bullets. There seems to have been some confusion between the parties about the delivery terms. Tallerman wanted to obtain the 2 million bullets gradually as they were progressively sold. Nathan's Merchandise presumed they wanted all 2 million bullets immediately. The result was that Nathan's Merchandise ended up with pallets of bullets they didn't want, but that Tallerman was refusing to take. They entered into negotiations about what to do, and Tallerman sent an offer outlining a compromise. The details of it don't really matter, but a compromise was on offer. Nathan's Merchandise accepted the offer by a return letter, but that letter was never received or acknowledged by Tallerman's. So, did they have a deal? There's an old rule of contract law which basically says that if acceptance of an offer is sent by post, the acceptance becomes valid as soon as it's sent. That would have meant the parties did have a deal. That rule, the postal acceptance rule, made a lot of sense back in the 19th century when post was the fastest form of communication. Unless parties were face to face, the post was how business was done. By the 1950s, though, this was no longer true. And so in this case, Chief Justice Nixon and Justice Fulligar brought the postal acceptance rule up to date a little. They said the general rule is that a contract is not completed until acceptance of an offer is actually communicated to the offeror, and a finding that a contract is completed by the posting of a letter of acceptance cannot be justified unless it is to be inferred that the offeror contemplated and intended that his offer might be accepted by the doing of that act. In this case, they found that the parties had been negotiating backwards and forwards, and a range of solutions had been proposed, and so it made no sense for the postal rule to apply. The contract would be formed only when acceptance actually reached Tallerman's. As a result, the compromise deal had never been accepted.